Welcome to today's program, Understanding and Managing Generative AI Legal Practice Risks. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our topic today is artificial intelligence, AI, and how this technology, particularly the new species known as generative AI, that has the ability to generate content in the form of text, images, video, audio, etc., in response to prompts from a user, is poised to change how knowledge workers, including lawyers, do our jobs. The potential is staggering, but so are the risks, particularly in the current nascent state of things, where generative AI chatbots, such as ChatGPT from a company called OpenAI, which recently was acquired by Microsoft, Bing Chat, also from Microsoft and now powered by ChatGPT, and Bard from Google, have been released to the public, and millions of people have started using them for all manner of things. Most of this experimentation is a good thing, and I suggest you try these services for yourself, just so you can see what they can do, including, a little later, some things you can try while you are viewing this program. Prepare to be very impressed, if not full out amazed. But before you consider using generative AI to assist in your law practice, you need to pause to make sure you understand exactly how these tools work, what they can do and what they can't, how reliable they are or aren't, and most importantly, what legal ethics issues can arise. The purpose of today's program is to give you the knowledge you need to perform that exercise for yourself as these and other generative AI tools continue to evolve. Most lawyers are cautious by nature, dipping our toes into new technologies only after careful consideration of the risks and benefits. At the risk of dating myself, when I was a young lawyer and email was a relatively new thing, my law firm debated for nearly a year whether it could be used for client work. The benefits were obvious: instantaneous communication and transmittal of documents in a world where messengers and fax machines were the norm. But so were the risks: inadvertent disclosure of confidential information because emails could be misaddressed or in some cases intercepted. And my law firm wanted to make sure that we had legal industry standard safeguards in place before they issued us our first BlackBerries. I recognize how dated this makes me sound, but the parallel to generative AI is too clear to resist. Just like email, generative AI holds the potential to make the practice of law much more efficient, but carries with it serious risks like the inadvertent disclosure of client confidential information, among others, that require all lawyers to proceed carefully, thoughtfully, and deliberately. Of course, not all lawyers approach their law practice, or their lives in general, with that same level of caution that we do, or that their clients, frankly, have the right to expect. An infamous example is the recent case of the personal injury lawyer in New York who was sanctioned by a Manhattan federal district judge under Rule 11 for submitting an affirmation in response to a motion to dismiss that cited 6 federal court decisions that did not, in fact, exist. The lawyer asked ChatGPT to provide him with case law support for the argument he was making, and ChatGPT simply made up the cases. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. The lawyer didn't do anything to confirm that the cases were real before he submitted them to the court, basically claiming that he thought the results from ChatGPT were the same as results you would find by researching the same issue on Westlaw or Lexis. Needless to say, the federal judge who sanctioned him did not see it that way when he decided to impose what were the first ever sanctions for submitting fake cases generated by ChatGPT to a court. That case is so fascinating that I've made it the subject of its own CLE program that you can watch next if you're interested in learning more about it. For our present purposes, it's enough to make the point that lawyers can face serious consequences if they don't understand how generative AI tools work and don't take the time to learn. Before we can talk about the legal ethics issues that can arise from the use of generative AI, we need to provide some background on what these tools do and how they work. In other words, what is artificial intelligence, generative AI, and how did we get to where we are today? In providing you with this background, I'm going to do something fun. Inspired by a wonderful article entitled "The Implications of ChatGPT for Legal Services and Society," written by Andrew Perlman, who is the dean and a law professor at Suffolk University Law School, I used Bard and ChatGPT to generate much of the content in this background section. Professor Perlman did the same thing in the article he wrote, but he took it a step further by asking Bing Chat to answer a multiple choice and one essay question from a civil procedure exam that law students would be given. According to Dean Perlman, Bing Chat gave, quote, "remarkably good answers," end quote, to these questions. In a separate test, Dean Perlman asked Bing Chat 15 challenging multiple choice questions about legal ethics. Bing Chat got 12 out of the 15 right. Summing it up, Dean Perlman wrote, quote, "Simply put, Bing Chat is already operating at the level of a B+ law student, and it will only get better with time," end quote. I've included the site to Dean Perlman's article in the written materials, and I highly recommend that you read it. It's an eye-opening article about generative AI from a prominent member of legal academia. So, much like Dean Perlman, I wrote this section by prompting both Bard and ChatGPT with questions like, quote, "What is artificial intelligence?" end quote, copying the answers and then editing them down in some cases for length or to fit my presentation style. In general, both Bard and ChatGPT provided very good and useful answers to these background questions, although there was the occasional fail. For example, when I typed, quote, "What is artificial intelligence?" end quote, into Bard, it responded, quote, "I'm just a language model, so I can't help you with that," end quote. By contrast, ChatGPT produced a very accurate and well-written answer in response to the same prompt, which was, quote, "Artificial intelligence, AI, refers to the simulation of human intelligence in machines that are programmed to perform tasks that typically require human intelligence. It is a broad field of study that encompasses various subfields, such as machine learning, natural language processing, computer vision, robotics, and more. AI systems aim to mimic cognitive functions associated with human intelligence, including perception, reasoning, learning, problem solving, and decision making. These systems are designed to analyze and interpret vast amounts of data, identify patterns, and make predictions or take actions based on the analysis. There are two primary types of AI. Number one, narrow AI, also known as weak AI. Narrow AI is designed to perform specific tasks within a limited domain. Examples include virtual assistants like Siri and Alexa, recommendation algorithms used by streaming services, and fraud detection systems in banking. Number two, general AI. General AI, also referred to as strong AI or artificial general intelligence, AGI, refers to AI systems that possess human-level intelligence and can understand, learn, and apply knowledge across various domains. General AI aims to exhibit the same level of intelligence and versatility as humans. Key techniques and approaches used in AI development include 1. Machine learning, Machine learning algorithms enable AI systems to learn patterns and make predictions or decisions based on data without being explicitly programmed. This approach involves training models on large data sets and iteratively refining them to improve performance. Number 2, deep learning. Deep learning is a subset of machine learning that uses artificial neural networks inspired by the structure and function of the human brain. Deep learning models, known as artificial neural networks, are capable of learning hierarchical representations of data, enabling them to process complex information and perform tasks like image recognition or natural language processing. 3, natural language processing. Natural language processing focuses on enabling computers to understand, interpret, and generate human language. It involves tasks such as speech recognition, language translation, sentiment analysis, and chatbots. Number 4, computer vision. Computer vision involves teaching machines to understand and interpret visual data, such as images and videos. It enables AI systems to perform tasks like object recognition, facial recognition, and image captioning. AI has applications in various fields, including healthcare, finance, transportation, cybersecurity, entertainment, and law, among others. Its potential impact on society, ethics, and the future of work has prompted ongoing discussions and debates." End quote. I think you'll agree both that ChatGPT's response was a solid answer and a very helpful overview of AI. It was particularly helpful in that it saved me probably a half hour of time that I otherwise would have spent researching the question using Google searches and then writing those paragraphs. Therein lies the power and promise of generative AI. At this point, I'm simply going to refer to ChatGPT as a catch-all for all of the generative AI tools that currently include Bard, Bing Chat, ChatGPT, etc. To the extent I found differences in their output, they were minor, apart from the odd hiccup or two like the one I mentioned earlier, and each service produced very similar results. What's more, ChatGPT is probably the most well-known of these tools as of this writing, so it is easier simply to refer to ChatGPT when the distinctions between the various services aren't important to the point I'm making. So, our new friend ChatGPT, what is generative AI? Quote, generative AI refers to a subset of artificial intelligence that focuses on creating or generating new content, such as images, music, text, or even entire simulations, based on patterns and examples from existing data. Unlike other AI approaches that primarily aim to analyze or classify existing data, generative AI systems aim to produce new and original content. Generative AI utilizes techniques like generative models, which are algorithms designed to learn the underlying patterns and structures of a given dataset. These models can then generate new data that resembles the patterns observed in the training data. Here are a few examples of generative AI applications. Number 1, image generation. Generative models can learn from large data sets of images and generate new images that resemble the patterns and features present in the training data. This has applications in areas like art, design, and computer graphics. Number 2, text generation. Generative AI models can be trained on vast amounts of text data, such as books, articles, or conversations, and generate new text that follows similar patterns. This is utilized in tasks like language generation, dialogue systems, and content creation. Number 3, music composition. By analyzing existing music compositions, generative AI can learn patterns and create new pieces of music in various genres or styles. It has applications in music production, composition assistance, and generating background music for media. Number 4, video synthesis. Generative AI models can learn from videos and generate new video sequences that resemble the training data. This can be used for tasks like video prediction, video completion, or generating synthetic training data for computer vision algorithms. Generative AI holds great potential for creative applications, content creation, and assisting human designers or artists. However, it also raises ethical considerations, such as issues related to ownership of generated content, potential biases present in training data, and the responsible use of AI-generated outputs. It's important to note that while generative AI can produce impressive and realistic results, it is still an ongoing area of research and development. The generated content may not always be perfect or indistinguishable from human-created content, and the quality and ethical implications of generative AI outputs should be carefully considered in practical applications." End quote. Again, that's a pretty accurate and useful summary. Of course, our focus today is going to be on the legal ethics issues, but as noted in the summary, there are many other ethical issues that generative AI can raise, in addition to legal and regulatory issues. We aren't going to talk about those issues in today's program, but you should be aware that they are out there and worthy of thoughtful examination as well. You might be tempted to ask, why is AI having a moment right now? Because it's been around in one form or another for decades, right? Well, yes. AI was pioneered in the 1960s by Joseph Weizenbaum at MIT, who created the first chatbot, Eliza. Eliza was designed to simulate a psychotherapist and was based on a simple, rule-based system that allowed it to generate responses that were similar to those of a human therapist. Chatbot development continued in the decades that followed, producing more sophisticated chatbots that were able to hold more complex conversations. In the 2000s, chatbot development took a major leap forward with the development of large language models, LLMs. LLMs are trained on massive data sets of text and code, which allows them to generate more realistic and human-like text. Bard and ChatGPT are two of the most advanced chatbots that have been developed using LLMs. The next major milestone occurred on November 20th, 2022, when OpenAI released ChatGPT-3. ChatGPT-3 is one of the largest language models ever created, with 175 billion parameters, and is trained on a vast amount of text data. As a result, ChatGPT can generate human-like text in a wide range of contexts and has been used in a variety of applications, including language translation, summarization, and question answering. The release of ChatGPT-3 and other advanced language models has opened up new possibilities for their use in a variety of fields, including the legal profession. That is why generative AI is having its moment right now. Lest you think this is all hype, like virtual reality, the metaverse, and blockchain, that were all supposed to change the game but so far haven't, there are some very smart people saying that generative AI is different and that we should believe the hype. Sundar Pichai, Google's CEO, recently said, quote, "AI is one of the most important things humanity is working on. It is more profound than, I don't know, electricity or fire," end quote. That's a bold statement from a very smart guy, so I think we should pay attention to this new tool. But we also need to temper our enthusiasm by listening to another very smart guy, OpenAI CEO Sam Altman, whose company created ChatGPT and who emphasized shortly after its release that it would be a, quote, "mistake," end quote, to rely on ChatGPT, quote, "for anything important right now," end quote. So how do chatbots like ChatGPT actually do what they do? There are highly technical explanations, but for lay people, that includes most lawyers, let me offer a few common sense analogies. ChatGPT works by predicting the next word or token based on the sequence of words in the prompt. One way to think of this is that it's like autocomplete on steroids. You've no doubt seen autocomplete work when you're composing emails or texts to predict the ending of words or phrasing that you start. ChatGPT takes this to a whole other level by predicting the answer to questions that you ask, which seems to the user like the chatbot is answering the question. ChatGPT is able to do this by using neural networks that are loosely based on the architecture of our brains, but in this case, each neuron is connected to many other neurons, 175 billion connections in ChatGPT-3. ChatGPT models are then trained to predict the next word by calibrating the strength of the connections between neurons to minimize prediction errors, much like calibrating coefficients in a regression. I hope that gives you some sense of how ChatGPT does what it does without causing your eyes to roll back in your head. Another absolutely key takeaway, you must never forget that chatbots are not humans and they have no concept of truth, no values, and no reflection. Because ChatGPT has no concept of truth, if it provides you with an answer that isn't accurate, ChatGPT has no way to distinguish it from an accurate one. ChatGPT served up the answer it did because your prompt correlated best with that answer, even if the answer turned out to be wrong. As two commentators who took ChatGPT for a test drive aptly put it, quote, ChatGPT-3 is currently the opposite of a lawyer. ChatGPT delivers wrong answers with a high degree of confidence. Good lawyers deliver well-researched information with a substantially moderated level of competence, couching answers with maybe and probably and it depends. Lawyers are highly self-conscious about the consequences of being wrong, and even more aware of the potential disaster that giving a wrong answer confidently could have on their case, their client, and their law license. ChatGPT, meanwhile, does not know or care if it is wrong, end quote. Now, I told you that most of this background section was written by ChatGPT. I also told you that one of the main issues with content generated by ChatGPT and other generative AI tools is their accuracy, or perhaps more accurately, their lack of accuracy. So is it accurate or isn't it? And if the latter, why are you using it to create your presentation? The short answer is that the content created by generative AI very well might be accurate, but you can't rely on its accuracy without checking it for yourself. I'll talk more about this later, but I think of the content ChatGPT creates like a memo of law written by a summer associate at a law firm. Let's assume the memo is well written. Most law students are good writers. There are no major spelling or punctuation errors, and the sentences are complete and they make sense grammatically. So there are no obvious red flags that suggest the writer didn't know what he or she is doing. This is very much like the content produced by ChatGPT. It is polished and there are generally no obvious red flags in terms of spelling, punctuation, or grammatical errors. But when you are reading a memo of law, what you really need to know is, does the memo accurately set forth the state of the law on the topic of the memo? What real lawyers do with memos of law written by summer associates is that they read them, and then they do their own research to see if the summer associate got it right or wrong. If the memo says that a case stands for XYZ proposition of law, summer associates can often get that wrong, and very often 180 degrees of wrong, because they miss the whole point of the case. This is particularly true when you are applying a legal rule to the facts of your case, i.e. performing legal analysis. If you miss a key distinction that a case is making, for example, that the driver of a car involved in an accident was an employee of the defendant acting within the scope of his or her employment at the time of the incident, you'll come up with the wrong answer when you apply the legal rule to the facts of your case. ChatGPT has the same flaws as an inexperienced and sometimes careless summer associate, and so its work product must be checked and verified exactly the same way. That is part of the problem with ChatGPT content. It seems plausible. Just like a memo of law from a summer associate seems plausible, and you may want to believe that it's right because it looks polished and cogent. But it could be completely wrong. What lawyers don't do, with the exception of the personal injury lawyer in the ChatGPT sanctions case, is take a memo of law written by a summer associate and file it with the court. If you think about content generated by ChatGPT as that summer associate memo of law, you'll be in the right frame of mind for how you should approach that content. Let me illustrate the point with another example. I asked ChatGPT to, quote, tell me about Abraham Lincoln's childhood and early political career, end quote. And here is what it produced. Quote, Abraham Lincoln, one of the most renowned American presidents, had a humble childhood and embarked on a notable political career. Abraham Lincoln was born on February 12, 1809, in a log cabin in Hardin County, Kentucky, which is now part of LaRue County. He was the second child of Thomas Lincoln and Nancy Hanks Lincoln. At the age of 7, Lincoln and his family moved to Indiana, settling in Spencer County. Lincoln's childhood was marked by poverty, hard work, and a thirst for education. Although Lincoln received limited formal education, he was an avid reader and self-learner. He borrowed books and educated himself on various topics, including history, politics, law, and literature. His love for learning and intellectual curiosity would play a significant role in his future endeavors. Lincoln's political career began in the 1830s when he became involved in local politics in Illinois. He ran for the Illinois General Assembly in 1832, but was unsuccessful. However, he won a seat in the state legislature in 1834 and served 4 consecutive terms. During his time in the legislature, Lincoln championed causes such as infrastructure development, education, and economic growth. Lincoln studied law and became a licensed attorney in 1836. He moved to Springfield, Illinois, where he established a successful law practice. His legal career flourished, and he gained a reputation for his analytical skills, honesty, and ability to persuade juries. As Lincoln's reputation grew, so did his political aspirations. He joined the newly formed Whig Party and actively participated in political campaigns and debates. In 1846, he won election to the U.S. House of Representatives, representing Illinois' 7th Congressional District. Lincoln served one term in Congress where he opposed the Mexican-American War and criticized President James K. Polk's policies. After his term in Congress, Lincoln returned to his legal practice, primarily focusing on his law career for the next few years. However, he remained engaged in political discussions and issues of national importance, particularly regarding slavery, which was becoming an increasingly contentious issue in the United States. In 1858, Lincoln ran as the Republican Party candidate for the U.S. Senate from Illinois, challenging the incumbent Stephen A. Douglas in a series of renowned debates. Although Lincoln lost the Senate race, the debates raised his national profile and established him as a formidable political figure. In 1860, Lincoln won the Republican Party's presidential nomination. He went on to win the presidential election, becoming the 16th president of the United States. His victory led to the secession of several southern states, which ultimately led to the American Civil War. Abraham Lincoln's childhood shaped his character, resilience, and commitment to education and self-improvement. His early political career laid the foundation for his eventual rise to the presidency, where he faced the significant challenges of leading a divided nation through a civil war and ultimately emancipating enslaved individuals through the Emancipation Proclamation. His legacy as a leader and his dedication to preserving the Union and abolishing slavery continue to be celebrated and studied today." End quote. If I had one word to describe ChatGPT's response, it would be plausible. I'm no Abraham Lincoln scholar, but to me, everything in that response seems plausible in that it could be true. President's Day is celebrated in February, so it certainly makes sense that Lincoln's birthday is on February 12th, and 1809 seems about right in terms of the year. Could he have been born in 1810 and not 1809? Absolutely. So you just don't know if it's accurate. I did check his birthday with other sources, and it is in fact February 12th, 1809. But my point is that you might not take the time to check that fact because February 12th, 1809 seems plausible. That is the temptation of content created by ChatGPT. It's presented to you in a format that is well written with no obvious red flags, and the substance of what you are being provided seems plausible. So plausible that you might be tempted not to check it, but you must. That is the trap the ChatGPT sanctions lawyer fell into. ChatGPT showed him excerpts from cases that looked like cases. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. These cases looked plausible, so the lawyer didn't check them. That mistake led to sanctions. Now, if ChatGPT had included a sentence that Abraham Lincoln traveled between campaign stops in an electric car, you'd immediately know that that couldn't possibly be true. But in my experience, ChatGPT rarely throws up those kinds of red flags, unless you're talking about a subject where you are an expert yourself and could spot any mistake, no matter how small, that nearly everyone else would miss, which is why it is so tempting to trust what ChatGPT is telling you. The next time ChatGPT presents you with some slick content that seems to nail the answer to whatever question you asked it, remember those summer associate memos of law and act accordingly. Before we dive into the legal ethics issues that can arise when lawyers use ChatGPT, let's talk for a moment about the broader implications that generative AI is likely to have on all knowledge workers, including lawyers. ChatGPT and similar advanced language models stand to benefit knowledge workers across various fields in at least 5 areas. 1. Enhanced productivity and efficiency. ChatGPT can serve as a powerful tool for knowledge workers, assisting them in tasks such as research, information gathering, and content creation. It can quickly provide relevant information, suggest ideas, or generate drafts, saving time and enhancing productivity. Number 2, improved decision-making and problem-solving. Knowledge workers often encounter complex problems that require extensive analysis and decision-making. ChatGPT can assist in this process by providing insights, alternative perspectives, and potential solutions based on its understanding of vast amounts of information. Number 3, access to expertise and knowledge. ChatGPT has the potential to democratize access to specialized knowledge. It can provide guidance and answers in diverse domains, making expertise more accessible to knowledge workers who may not have immediate access to domain experts or extensive resources. Number 4, language barrier mitigation. For knowledge workers in international or multicultural settings, language barriers can hinder effective communication and collaboration. ChatGPT, with its language capabilities, can help bridge these gaps by facilitating multilingual interactions, translation tasks, and cultural understanding. Number 5, learning and professional development. Language models like ChatGPT can facilitate continuous learning for knowledge workers. They can provide real-time information, explain concepts, offer tutorials, and engage in interactive learning experiences, thereby supporting professional development and skill enhancement. Clearly, the potential is there, but so are the risks and ethical considerations. Knowledge workers must be mindful of potential biases, misinformation, or inaccurate outputs that may emerge from AI systems. We'll talk more about these issues later, but as I alluded to before, human oversight is crucial to review, verify, and validate the information generated by ChatGPT, ensuring accuracy and responsible use. Knowledge workers also must be cognizant of legal implications related to privacy, data security, intellectual property, and confidentiality. They should exercise caution when sharing sensitive or confidential information with AI systems and ensure compliance with relevant laws and regulations. We'll also talk about some of these concerns in the context of our discussion of potential legal ethics issues. Turning now to the legal industry to set the stage for our legal ethics discussion, how will ChatGPT change the practice of law? I think Dean Perlman put it very well when he said, quote, "For the legal industry, ChatGPT may portend an even more momentous shift than the advent of the internet. A significant part of lawyers' work takes the form of written words in emails, memos, motions, briefs, complaints, discovery requests and responses, transactional documents of all kinds, and so forth. Although existing technology has made the generation of these words easier in some respects, such as by allowing us to use templates and automated document assembly tools, these tools have changed most lawyers' work in relatively modest ways. In contrast, AI tools like ChatGPT hold the promise of altering how we generate a much wider range of legal documents and information. In fact, within a few months of ChatGPT's release, law firms and legal tech companies are already announcing new ways of using generative AI tools." End quote. I want to focus on 4 areas where ChatGPT is expected to help lawyers do our jobs. Number 1, legal research. ChatGPT can be used to research legal topics quickly and easily. It can be used to find relevant case law, statutes, and regulations. It also can be used to summarize complex legal concepts. Number 2, legal document generation. ChatGPT can be used to draft legal documents, such as contracts, wills, and pleadings. It can be used to generate boilerplate language and to customize documents to the specific needs of a client. Number 3, legal analysis. ChatGPT can be used to analyze case law and to identify potential legal arguments. It can be used to identify the strengths and weaknesses of a case and to develop strategies for winning a case. Number 4, legal information. ChatGPT can be used to provide general legal information to the public, such as answering frequently asked questions or providing basic legal advice. Once again, rather than me telling you about how ChatGPT can help lawyers with legal research or legal document generation or legal analysis, I'll take another page out of Dean Perlman's excellent article and ask you to see for yourself. While you're reviewing this program, do a Google search for ChatGPT, Bard, or Bing Chat, log in or create a free account, and then run some queries for yourself. When you do this for the first time, you'll be presented with several very important disclaimers, and we'll talk about them in detail later. For now, just click through and let's get some hands-on experience with ChatGPT. For legal research, prompt ChatGPT to, quote, "explain the concept of personal jurisdiction," end quote, or ask it to, quote, "draft a brief to the U.S. Supreme Court on why its decision on same-sex marriage should not be overturned," end quote, and see what you get. I think you'll be very surprised and impressed by the quality of the responses. This is where you need to remember the summer associate memo and my new favorite word, plausible, because that is exactly what ChatGPT will be outputting to you. Dean Perlman, after summarizing the overall quality of Bing Chat's legal analysis as mimicking the level of a B+ law student, he was quick to add, quote, "To be clear, the responses generated by ChatGPT were imperfect and at times problematic. For example, the legal documents are incomplete, and its discussion of certain topics like personal jurisdiction lack nuance, end quote. This is why I think my summer associate legal memo analogy is spot on. It's like the work of a B+ law student in terms of level of experience and knowledge, and it should be treated accordingly. I wonder how many summer associates these days are going to be using ChatGPT to prepare their legal memos. It certainly would save them some time and allow them to get to their fancy lunches and summer associate events that much earlier. To get a sense of the possibilities for legal document generation, prompt ChatGPT to, quote, develop a list of deposition questions for the plaintiff in a routine motor vehicle accident in Massachusetts, end quote. Or, quote, create a contract for the sale of a 2018 Toyota Prius from Jane Smith to John Doe in Massachusetts for the sale price of $15,000. The contract should contain the usual representations and warranties of such a sale, end quote. And see what you get. 80% of the way there as a first draft might be a good way to describe it. Again, that's your B+ law student or your summer associate that you gave this assignment to, and so you take it for what it's worth, and you basically redo it to make sure it's correct. Of course, what you don't do is hand the list of deposition questions to your litigator and say, here you go, we're all set. You don't send the draft contract of sale to your client for review and approval. These are first, preliminary, working drafts that are helpful, but not something that you should consider complete or reliable. Skilled lawyers will see not only what is wrong or incomplete in the response, but also what is missing, which is often equally, if not more important. I don't need to belabor the point any further, but with these few examples, I think you can see both the potential benefits and potential risks associated with using ChatGPT to assist lawyers in these ways. Let's move now to legal analysis, because that's where the real fun begins, in terms of setting us up to talk about potential legal issues. Go to ChatGPT and prompt it with the following hypothetical. And you can read or copy the text of this from the script for this presentation included in your written materials, so don't feel you need to copy down verbatim what I'm saying next. Quote, assume the following information. Desert Casino is incorporated and has its principal place of business in Louisiana. Desert advertises in television commercials throughout Louisiana and neighboring states, including in Florida. Otherwise, Desert conducts no activities in any state other than Louisiana. Penny is an avid gambler and knows of Desert because she grew up in Louisiana near the casino. Penny, however, recently moved to Florida for a 2-year master's degree in business administration at Florida State University. Her plan is to stay in Florida after she gets the degree, but only if she finds a good job in the state. Otherwise, she plans to return home to Louisiana so that she can be closer to her family and her favorite casino, Desert. While a student at Florida State, Penny takes a road trip to Desert. Penny wins big, a $13,000 cash jackpot. Unfortunately, Penny is mugged in Florida when she arrived at her rental apartment, and her cash is stolen. Apparently, criminals stake out the casino waiting for big winners and follow them home to steal their money. Penny sues Desert in federal district court for the Northern District of Florida, which is where Penny is living while a student, alleging that Desert has a policy of providing police protection to big winners, over $10,000, and that Desert failed to follow the policy in her case. Thus, Penny asserts a claim for breach of contract and negligence. She seeks to recover the $13,000 she lost to the muggers, as well as $70,000 for the emotional trauma of getting mugged and having the money stolen. Penny expects that Desert will contend that federal law prohibits armed security guards from crossing state lines, so the policy could not have been followed in Penny's case. Penny alleges in her complaint that the federal law is not applicable to this case because Desert could have sent bodyguards to accompany her, even if they were not armed. Assume Desert makes motions to dismiss on the grounds that the court lacks subject matter jurisdiction and personal jurisdiction, and moves to transfer to the Eastern District of Louisiana, which is where Desert is located and where Desert's headquarters are. Please discuss how the court should resolve all of the motions identified above and why you believe the court should do so. Be sure to consider any reasonable counterarguments and why you consider them to be unpersuasive." End quote. Now, see what you get. Very likely, you'll see a decent answer, but likely also one that lacks nuance, misses a few key sub-issues, and maybe applies the wrong law to the question. But, at the same time, you'll get something that is generally responsive to the question and makes more valid points than invalid ones. Back to our B+ law student and green summer associate. Now, as a former law clerk in federal district court, I'm starting to worry about future law clerks simply typing in the facts of the cases that are before the court and asking ChatGPT to write the opinion resolving the motion to dismiss. Is the judge, in reviewing the draft opinion, going to apply my summer associate legal memo rule and essentially redo all of the research, him or herself? Highly unlikely. Are law clerks members of the bar and subject to the legal ethics rules? Sometimes, but generally not. This is scary stuff if we actually get to a place where that becomes commonplace. Finally, let's look at a couple examples of using ChatGPT for legal information. Prompt ChatGPT as follows. Quote, I have a disagreement with my child's school district in Massachusetts regarding the creation of an IEP. What should I do? End quote. Or, quote, the government hasn't paid me the correct Social Security amount. What should I do? End quote. And see what you get. In both cases, the answers are pretty good. Now, whether either of these answers contains legal advice is debatable, and we'll talk about that later. But I think you could say that it's generally good advice, particularly for someone who doesn't have access for financial or other reasons to a lawyer. Now, the unauthorized practice of law statutes exist to protect the public from legal advice being provided by non-lawyers, and part of the reason is that such advice very well could be wrong. It could be incomplete. It could be based only on certain information that you provided, without knowing to ask you the key questions to uncover other relevant facts. ChatGPT suffers from all of these problems in spades, so it's still equivalent to asking that B or B+ law student for legal advice, and that law student would be engaging in the unauthorized practice of law if he or she agreed to help you in any formal way, because of course law students are not licensed to practice law. As with the other three areas, the promise is there for ChatGPT to provide legal information to the public, but there are many, many issues that would need to be resolved before ChatGPT could be used in this way. Having now gone a couple of rounds with ChatGPT yourself, I want to point out a few things that you might now begin to appreciate. As AI expert Lance Elliott put it in an excellent article, which is also cited in the written materials, and I would urge you to read it, quote, generative AI apps are exceedingly easy to use. All you need to do is enter a prompt and the AI app will generate for you an essay that attempts to respond to your prompt. The composed text will seem as though the essay was written by the human hand and mind. Your first thought might be that this generative capability does not seem like such a big deal in terms of producing essays. You can easily do an online search of the internet and readily find tons and tons of essays on any topic. The kicker in the case of generative AI is that the generated essay is relatively unique and provides an original composition rather than a copycat. If you were to try and find the AI-produced essay online someplace, you would be unlikely to discover it. Generative AI is pre-trained and makes use of a complex mathematical and computational formulation that has been set up by examining patterns in written words and stories across the web. As a result of examining thousands and millions of written passages, the AI can spew out new essays and stories that are a mismatch of what was found. By adding in various probabilistic functionality, the resulting text is pretty much unique in comparison to what has been used in the training set, end quote. This is how the output of ChatGPT differs from what a standard Google search would return. It's an original composition, not a copy of something that someone else previously had written. That's a huge difference and part of what makes ChatGPT so exciting. The flip side of not copying verbatim prior content is that ChatGPT makes it very difficult to determine when somebody is using it to generate content. Think about the college student who turns in an essay that he purchased online, or maybe he wrote the essay himself, but he copied and pasted large sections of it from materials that he found online. Lance Elliott again describes how ChatGPT already has changed the game. Quote, that's why there has been this uproar about students being able to cheat when writing essays outside of the classroom. A teacher cannot merely take the essay that deceitful students assert is their own writing and seek to find out whether it was copied from some other online source. Overall, there won't be any definitive pre-existing essay online that fits the AI-generated essay. All told, the teacher will have to begrudgingly accept that the student wrote the essay as an original piece of work, end quote. The same is true for lawyers who use ChatGPT to write their briefs, law students to write their take-home exams, and law clerks to draft judicial opinions. it will be very difficult to prove that any of them used ChatGPT to create their original work. Now, you'll have examples like the personal injury lawyer who copied in ChatGPT content that cited 6 cases that in fact did not exist, and he was caught when the opposing party pointed this out to the federal district judge, who tore into that lawyer. Ironically, if the judge's law clerks had used ChatGPT to draft the opinion in that case, might they have found the same 6 fake cases? How funny, but actually how scary would that have been? But I digress. The point is that ChatGPT generates original content that will be hard for others to identify as the output of ChatGPT because it is original and not an exact copy of anything that came before it. The next point is illustrated by the following example, also from Lance Elliott's excellent article. Quote, I described in one of my other columns the following experiment that I undertook. An attorney was trying to discover a novel means of tackling a legal issue. After an exhaustive look at the legal literature, it seemed that all angles already surfaced were found. Using generative AI, we got the AI app to produce a novelty of a legal approach that had seemingly not before been previously identified. It was believed that nobody else had landed on this legal posture, a legal golden nugget, as it were. This could be strategically valuable competitive legal bonanza that at the right time be leveraged and exploited. Does that outputted essay constitute a form of confidential information, such that it was generated by AI for this particular person and contains something special and seemingly unique? Aha, this leads us to the other allied and intertwined topic about the ownership and IP rights associated with generative AI. Stay tuned to see how this turns out, end quote. The short answer is no, there is no protection for that essay. So even if you were lucky enough to use ChatGPT in a way that produced a substantial benefit, you came up with a novel legal theory that you could employ on behalf of your clients, you wouldn't be able to protect it, and it instantly would become part of the data set that others who are researching similar issues on ChatGPT could find. While you might argue that once you've filed a brief that includes your novel theory, or maybe once your theory is adopted by a court in a published opinion, it can be copied by others. It's a different thing for as soon as you come up with the idea, it's immediately out to everyone, globally, with no protection for you or your client. Like many other things, ChatGPT takes something that exists today and turbocharges it, for better or for worse. So don't put your best insights or legal arguments into ChatGPT thinking that they're confidential. The final observation also comes from Lance Elliott. Quote, the allure of these generative AI apps is quite magnetic once you start using them. Step by step, you find yourself mesmerized and opting to put your toes further and further into the generative AI waters. The next thing you know, you are readily handing over proprietary content that is supposed to be kept private and confidential into a generative AI app. Resist the urge and please refrain from stepwise falling into an unsavory trap. Now that you've seen how easy it is to ask ChatGPT to write you an essay on any topic, legal or otherwise, you might be tempted to go back to the well time and time again. Maybe you're even tempted to try to improve the essay by giving ChatGPT feedback. Look more into this, or don't bother including that, like you would if you were interacting with a summer associate or junior lawyer to whom you'd assigned the task of writing the essay or legal memo. That is a slippery slope, not only because you get invested in what ChatGPT is creating, which very likely could be wrong, but you're now sharing more content with ChatGPT in your prompts. You might be including relevant facts that you learn from client confidential communications. You might be applying your own legal or strategic insight to the problem in an effort to steer ChatGPT in the right direction. As we will see next, providing information to ChatGPT discloses it to the world, so that goes for client confidences, as well as your own legal insights and strategy, where it can be accessed and used by others. This is the, quote, unsavory trap, end quote, Lance Elliott is referencing. And for lawyers, that trap includes the serious risk of legal ethics violations. Let's turn now to the legal ethics issues that can arise when you are contemplating using ChatGPT to assist you in your law practice. For someone who does a lot of legal ethics CLE programs, this topic presents a true embarrassment of riches. I'm going to cover 8 separate areas of legal ethics concerns for practicing lawyers. The sheer breadth of issues, and I believe I'm covering the most significant ones, but there are others too, means that I won't be able to cover each issue in too much depth in today's relatively short program. However, I I think it makes more sense to go wider instead of deeper, in part because these tools continue to evolve. My goal here is to provide you with what I would call legal ethics issue spotter guidance that you can use to evaluate specific generative AI tools and possible use cases to ensure that whatever use, if any, you make of these tools in your practice complies with your legal ethics obligations. Sometimes I joke that I'm giving you just enough knowledge in a CLE program to be dangerous, but I think the real value of this program is twofold. First, you now know a lot about how generative AI tools like ChatGPT work, and you've spent some time playing with them yourself, so you understand what we are talking about and how it can be used by practicing lawyers in terms of assisting with legal research, legal document generation, etc. Second, I will spot the potential ethics issues that can arise depending on the potential application of the tool, so you can evaluate that usage in light of the relevant legal ethics rules. Ready? Let's kick it off. The 8 areas of concern for practicing lawyers that I'm going to discuss today relate to your ethical obligations to 1. Be competent, 2. Maintain client competences, 3. Protect client property and data, 4. Be candid before the court, 5. Not bring frivolous claims, 6. Supervise non-lawyer staff, 7. Avoid the unauthorized practice of law, and 8. Not discriminate against others on the basis of protected characteristics. As I noted, there are other potential areas of concern, but I believe these 8 should be your main focus when thinking about potentially leveraging generative AI in your law practice, as we currently are seeing this new technology play out in the form of chatbot tools like ChatGPT. Let's begin with the duty of competency. ABA Model Rule 1.1 provides, quote, "A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation," end quote. This one is pretty easy and aptly illustrated by the personal injury lawyer in New York who was sanctioned for submitting a brief to a court that contained fake cases that ChatGPT simply invented. By relying solely on ChatGPT, a tool that he also failed to understand at even the most basic level, more about that in a moment, to provide him with case law to support his argument, this lawyer violated his duty of competent representation under ABA Model Rule 1.1. The main competency issue here is accuracy, or really the lack of accuracy, of the results that are being produced by ChatGPT. For any lawyer to behave the way the personal injury lawyer did here, i.e., to rely on the content being produced by ChatGPT in representing his client, you would need to be confident that ChatGPT produces accurate and reliable results. That is not the current state of things. Think about the summer associate legal memo analogy. You would violate ABA Model Rule 1.1, among others, if you relied on a legal memo written by a summer associate without independently verifying all of it. Another thing that bears mentioning is that most versions of ChatGPT only have data up through 2021. So anything that has happened since then, think the Supreme Court's decisions in the Dobbs case overturning Roe v. Wade or the Harvard case barring affirmative action in college admissions, would not be part of the data set on which ChatGPT was trained and could not inform ChatGPT's answers to your prompts. That's a huge limitation. What if Westlaw had the same limitation? Would you feel confident in your legal research if Westlaw didn't include any cases decided after 2021? Beyond the gaps and the possibility of completely invented cases or other information, there is the very real problem that ChatGPT may not always be able to account for the nuances and complexities of the law. Because ChatGPT is a machine learning system, it does not have the same level of understanding and judgment as a human lawyer when it comes to interpreting legal principles and precedent. This could lead to problems in situations where a more in-depth legal analysis is required which is most legal problems where significant amounts of money are at stake. We saw ChatGPT give a pretty good answer to how to dispute an underpayment of your Social Security benefits, but that's very different from providing an answer to the hypothetical about whether the court has subject matter and personal jurisdiction, which is quite complex. Another good analogy is the difference between searching WebMD or some other website when you're feeling sick and you're trying to figure out what you might have versus going to see a doctor. If you're like me, you've fully convinced yourself that you have a rare form of cancer by doom scrolling through medical sites online, only to be told by a doctor that all I need was an antibiotic. While ChatGPT may be able to assist doctors and lawyers with daily tasks and improve their efficiency, it can never be viewed as a replacement for the skills, judgment, and experience that doctors need to practice medicine and that lawyers need to practice law. While it's impressive that ChatGPT can match the success rate of the B+ law student, that's hardly the standard by which the competency of practicing lawyers is judged under ABA Model Rule 1.1. Nor would you want your cancer treated by a B+ medical student. Interestingly, while this aspect of the duty of competence is straightforward, don't rely on a tool that isn't reliable, and you could fully satisfy that aspect of this duty by saying, I'm not going to go near this thing until it's 100% accurate, there is another aspect of this duty that actually requires lawyers not to bury their heads in the sand and ignore ChatGPT entirely. Comment number 8 to ABA Model Rule 1.1 provides, quote, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. Remember my earlier story about the early days of email. Responsible lawyers didn't ignore the technology, but rather they studied it carefully and only incorporated it into their legal practice once they could be confident that they were taking the necessary precautions to minimize the risks of using email. Fast forward 30 years, and I think you could argue that any lawyer who doesn't use email for client work, at least in cases where it benefits the client, isn't fulfilling his or her duty to provide competent representation. Perhaps a better example is a lawyer who insists on verifying the accuracy of cases by shepherdizing them using the actual books because he doesn't know how to use Westlaw or Lexis. I don't even know if they make the Shepherd's books anymore, but I think you see the point. A lawyer can't fulfill his or her duty of competency that includes the duty to, quote, keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, end quote, by ignoring new technologies like ChatGPT. If Sundar Pichai is right, and generative AI is going to be as important as electricity, lawyers will need to learn how to use it responsibly, just as we did when email, electronic legal research, e-filing, and every other innovation came along. ChatGPT is clearly not there yet, but we all have an ethical obligation to keep an eye on it to make sure that if, when, and how it can be used in our practices, consistent with our other ethical obligations, that we do so. Part of these changes will need to be driven by law schools, and to a lesser extent by CLE programs like this one, to educate the next generation of lawyers on these technologies, just as we learned about the newest technologies of the day when we were law students. I learned how to shepherdize cases using the books because online legal research was still relatively new at the time. But we learned both, and the latter quickly replaced the former. Once again, I think Dean Perlman nailed it on both points when he wrote, quote, law schools will face numerous related questions and challenges. In the short term, they will have to grapple with how to assess student performance on take-home exams and papers now that students have easy access to AI tools. Looking further ahead, law schools will probably have to incorporate these tools into the curriculum in much the same way as they have taught students how to use electronic research tools. For example, first-year legal writing classes and clinical programs may need to teach AI document drafting so that future lawyers understand how to use the technology in practice. At my law school, Suffolk Law, we've demonstrated ChatGPT's capabilities to the faculty and have encouraged them to consider not just the threats from these tools, but the extent to which we should be actively teaching students how to use them. AI will not eliminate the need for lawyers, but it does portend the end of lawyering as we know it. Many clients, especially those facing complex issues, will still need lawyers to offer expertise, judgment, and counsel, but those lawyers will increasingly need AI tools to deliver those services efficiently and effectively. In fact, these tools are likely to become so valuable that lawyers may need them in certain contexts to satisfy their duty of competence, just as we would question the competence of a lawyer who shepherdizes citations using only books or prepares a legal document on a typewriter. In other words, clients will not want standalone lawyers who eschew AI. Conversely, clients with challenging legal matters are unlikely to rely on technology by itself. The future, at least for complex legal issues, will require the use of tech-enhanced lawyers, end quote. I don't think you can say it any better than that, so I'll leave it there. The second area of concern relates to your ethical obligation to maintain client confidences. I'm going to include in this grouping your related obligation, whether you file it under competency or here under client confidences, to avoid taking any steps that might be held inadvertently to waive the attorney-client or attorney-work product privileges. ABA Model Rule 1.6a provides that, quote, "A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B," end quote. ABA Model Rule 1.6c states that, quote, "A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of, or unauthorized access to, information relating to the representation of a client," end quote. Comment number 18 to ABA Model Rule 1.6 provides, quote, "Paragraph C requires a lawyer to act competently to safeguard information relating to the representation of a client against unauthorized access by third parties and against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision." The unauthorized access to or the inadvertent or unauthorized disclosure of information relating to the representation of a client does not constitute a violation of paragraph C if the lawyer has made reasonable efforts to prevent the access or disclosure. Factors to be considered in determining the reasonableness of the lawyer's efforts include, but are not limited to, the sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, the difficulty of implementing the safeguards, and the extent to which the safeguards adversely affect the lawyer's ability to represent clients, for example, by making a device or important piece of software excessively difficult to use, end quote. Finally, comment number 19 to ABA Model Rule 1.6 states, quote, "When transmitting a communication that includes information relating to the representation of a client, the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. This duty, however, does not require that the lawyer use special security measures if the method of communication affords a reasonable expectation of privacy. Special circumstances, however, may warrant special precautions. Factors to be considered in determining the reasonableness of the lawyer's expectation of confidentiality include the sensitivity of the information and the extent to which the privacy of the communication is protected by law or by a confidentiality agreement," end quote. That's a lot to digest, but in the context of the chatbots that currently exist, using ChatGPT and Bard as our examples, The analysis is really easy. No lawyer can input any client confidential information into a chatbot without violating his or her duty to maintain client confidences under ABA Model Rule 1.6. Let me repeat that. No lawyer can input any client confidential information into a chatbot without violating his or her duty to maintain client confidences under ABA Model Rule 1.6. Period. Full stop. Nor is it a case of, I didn't know I couldn't do that, because both of these services expressly tell you that when you register for an account. I'm sure you noticed these warnings when you entered your prompts in ChatGPT earlier, but let's go through them to make it plain for everyone. When you open up ChatGPT, you see a window that states under the heading, quote, how we collect data, end quote, that, quote, conversations may be reviewed by our AI trainers to improve our systems, end quote, and, quote, please don't share any sensitive information in your conversations, end quote. If you choose to share sensitive information, ChatGPT in its terms of use makes it clear that it has no duty to protect that information. Under the section entitled, quote, confidentiality, security, and data protection, end quote, it states that, quote, confidential information means non-public information that OpenAI or its affiliates or third parties designate as confidential or should reasonably be considered confidential under the circumstances, including software, specifications, and other non-public business information, end quote. Under this definition, any information that users enter to prompt ChatGPT is not, quote, confidential information, end quote, that ChatGPT would be obligated to safeguard. The warnings given by Bard are similar, although you have to go to the Bard FAQ and the Google Generative AI additional terms and conditions in order to find all of them. In the Bard FAQ, under the heading, quote, what data is collected, how is it used, end quote, it states, quote, when you interact with Bard, Google collects your conversations, your location, your feedback, and usage information. That data helps us provide, improve, and develop Google products, services, and machine learning technologies, as explained in the Google privacy policy. For example, we use your feedback to increase the effectiveness of the Bard safety policies and help minimize some of the challenges inherent to large language models. And Bard uses your past interactions with it and your location to generate its response, end quote. Under the heading, quote, who has access to my Bard conversations, quote, it states, quote, we take your privacy seriously and we do not sell your personal information to anyone. To help Bard improve while protecting your privacy, we select a subset of conversations and use automated tools to help remove personally identifiable information. These sample conversations are reviewable by trained reviewers and kept for up to 3 years, separately from your Google account. Please do not include information that can be used to identify you or others in your Bard conversations, end quote. Finally, the generative AI additional terms and conditions provide under, quote, use restrictions, end quote, that, quote, you will not input any personal or sensitive information including names, phone numbers, addresses, emails, or birth dates, end quote. In light of these terms and the repeated warnings, quote, not to input any personal or sensitive information, end quote, into these services, it's clear that a lawyer violates ABA Model Rule 1.6 by entering any client confidential information into one of these chatbots as they are currently configured. You have not made, quote, reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client, end quote, if you enter client confidential information into ChatGPT. That is because you are expressly told that others can review what you input, and also that what you input is expressly excluded from the definition of, quote, confidential information, end quote, that these services are agreeing not to disclose. As the comments to ABA Model Rule 1.6 make clear, while you do not violate your duty to keep client confidences, if you disclose them to third parties after taking, quote, reasonable precautions to prevent the information from coming into the hands of unintended recipients, end quote, by, for example, ensuring that the disclosure is protected by law or by a confidentiality agreement, ChatGPT offers no such protection. Accordingly, such disclosures would violate your ethical obligations to maintain client confidences under ABA Model Rule 1.6. Before we leave our discussion of the terms and conditions that apply to ChatGPT and Bard, it bears noting that both services also repeatedly warn users not to rely on the accuracy of the output they receive. The window that opens when you launch ChatGPT expressly states, quote, "While we have safeguards in place, the system may occasionally generate incorrect or misleading information and produce offensive or biased content. It is not intended to give advice," end quote. On the ChatGPT homepage, under the section entitled, quote, "Limitations," end quote, it states that ChatGPT, quote, "may occasionally generate incorrect information, may occasionally produce harmful instructions or biased content, and limited knowledge of world and events after 2021, end quote. For its part, Bard's fact states that, quote, "Bard is experimental and some of the responses may be inaccurate. So double check information in Bard's responses," end quote. And its generative AI additional terms and conditions under, quote, "disclaimers," end quote, has the following. Quote, "The services use experimental technology and may sometimes provide inaccurate or offensive content that doesn't represent Google's views. Use discretion before relying on, publishing, or otherwise using content provided by the services. Don't rely on the services for medical, legal, financial, or other professional advice. Any content regarding those topics is provided for informational purposes only and is not a substitute for advice from a qualified professional," end quote. This is still further proof that a lawyer violates his or her duty of competence under ABA Model Rule 1.1 by relying on information provided by ChatGPT without independently verifying it after having expressly been warned not to do so. As I mentioned at the outset, the risk of waiving the attorney-client privilege and/or attorney work product protection goes hand in hand with potential disclosure of client confidential information. Assuming you have had conversations with your client that qualify for the attorney-client privilege, i.e., communications that concern, seek, or provide legal advice, or you have created documents that reflect your legal analysis in anticipation of litigation, such that the attorney work product protection might attach to those documents, those communications must be kept confidential in order for the privileges to be maintained. Comment number 13 to ABA Model Rule 1.6 states in no uncertain terms that, quote, "Disclosure of any information is prohibited if it would compromise the attorney-client privilege or otherwise prejudice the client," end quote. If you were to input information you learned from confidential attorney-client communications or information contained in attorney work product documents into a prompt in ChatGPT, that information has been disclosed and thus has not been kept in confidence. Indeed, it is highly likely in that scenario that such disclosure would be held to waive the attorney-client privilege and/or the attorney work product protection as applicable. This is yet another reason why lawyers must be extremely careful when they are thinking about using ChatGPT to assist in their law practice. Are there any solutions to the problem of potential disclosure of client confidences and/or waiver of the attorney-client or attorney work product privileges? As far as I can tell, there are only two possible solutions that would allow a lawyer to use some form of generative AI in his or her practice. The first solution is to obtain prior informed consent of the client. ABA Model Rule 1.6a provides that, quote, a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B, end quote. What would truly informed consent need to look like in this context? You need to explain to your client in writing, and this would have to be an extensive writing and signed consent form to protect both you and the client, all of the risks associated with using ChatGPT, including potential waivers of the attorney-client privilege and/or attorney work product protections that we've been discussing so far. It's hard to imagine any corporate or other sophisticated clients, maybe even any clients, agreeing to provide such consent in light of the disclosures you'd be required to make, given the current state of how ChatGPT handles information you supply to it in the prompts. Still, obtaining informed consent of the client prior to any such disclosure of client confidential information is one solve that ABA Model Rule 1.6 expressly provides for lawyers. The second solve is what many large law firms are already looking into, which is setting up their own confidential instance of a generative AI tool that only has access to information and documents within that firm. The idea is to give the generative AI tool, think of it as ChatGPT, but only for that law firm, access to all of the firm's prior art, complaints, motions, legal memoranda, deposition transcripts, copies of cases, etc., and have that be the basis upon which the AI tool is trained. So, when you ask that tool to draft a complaint, it will pull only from complaints and other useful documents that the firm previously has prepared for that and other firm clients, rather than pulling from the billions of publicly available data points that regular ChatGPT has access to. Maybe the results would suffer from the limited access, but maybe they actually would be better because it would follow the firm's pre-existing standards and precedents in creating new documents rather than suffering from the garbage in, garbage out problem that ChatGPT often does. Whether it's better or not, a huge benefit is that such a tool would not disclose client confidential information outside the firm. You'd enter that information into a prompt, but the law firm itself or a trusted vendor working for the law firm under a confidentiality agreement would manage the tool, so there would be no outside disclosure. If you're interested in exploring something like this for your law firm, and while I'm not an expert in this as it relates to law firm resources, my understanding is that Thomson Reuters Legal Drafting, Microsoft Copilot, and Casetext Co-Counsel are three such products that your law firm might want to find out more about. The third area of concern for practicing lawyers is your ethical obligation to protect client property and data. ABA Model Rule 1.15a provides, quote, a lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with a representation separate from the lawyer's own property. Funds shall be kept in a separate account maintained in the state where the lawyer's office is situated, or elsewhere with the consent of the client or third person. Other property shall be identified as such and appropriately safeguarded. Complete records of such account funds and other property shall be kept by the lawyer and shall be preserved for a period of 5 years after termination of the representation, end quote. We already talked about disclosing client confidences by entering that information into a prompt in ChatGPT, but what I'm talking about here is the iterative process of using the prompts and any output generated by ChatGPT as a result of your prompts. AI expert Lance Elliott cited an example that is illustrative. Quote, An attorney takes a drafted contract and copies the text into a prompt for ChatGPT. The AI app produces a review for the lawyer. Turns out that several gotchas are found by ChatGPT. The attorney revises the contract. They might also ask ChatGPT to suggest a rewording or redo of the composed text for them. A new and better version of the contract is then produced by the Generative AI app. The lawyer grabs up the outputted text and plops it into a word processing file. Off the missive goes to their client. Mission accomplished. Can you guess what also just happened? Behind the scenes and underneath the hood, the contract might have been swallowed up like a fish into the mouth of a whale. Though this AI-using attorney might not realize it, the text of the contract, as placed as a prompt into ChatGPT, could potentially get gobbled up by the AI app. It is now fodder for pattern matching and other computational intricacies of the AI app. This, in turn, could be used in a variety of ways. If there is confidential data in the draft, that too is potentially now within the confines of ChatGPT. Your prompt, as provided to the AI app, is now ostensibly a part of the collective in one fashion or another. Furthermore, the outputted essay is also considered part of the collective. If you had asked ChatGPT to modify the draft for you and present the new version of the contract, this is construed as an outputted essay. The outputs of ChatGPT are also a type of content that can be retained or otherwise transformed by the AI app. End quote. Let's assume the lawyer didn't include any client confidential information in the draft complaint, which you would expect since the complaint ultimately will be publicly filed. But those drafts of the complaint are now in the ether. In theory, those drafts or portions of them can be read by anyone and used by anyone. Absent the lawyer's use of ChatGPT, those drafts would be part of the client's legal files that would not be disclosed to anyone without the client's informed consent. But in our hypothetical, the lawyer has opened up those drafts to the world, and neither the lawyer nor the client no longer has any control over them. That is the opposite of a lawyer, quote, identifying, end quote, and, quote, appropriately safeguarding, end quote, client property and data as required by ABA Model Rule 1.15. While we have no way of knowing how this data might be used, it doesn't take too much effort to imagine uses that might prejudice the client. What if the lawyer who is representing the other party in the client's lawsuit is using ChatGPT to find arguments to support a motion to dismiss a potential complaint? Now, that lawyer's search results are going to be trained on actual drafts of the client's complaint. The other side's lawyer likely wouldn't know that or benefit specifically from that knowledge, but his or her motion to dismiss would be improved by having access to data that includes actual drafts of the complaint that will be filed in that action. It's not just the outputs in terms of a draft complaint that could prejudice the client, but also the prompt history. Recently, there was a data leak in ChatGPT that allowed its users to review the prompt history titles of other users, revealing the information of nearly 1.2% of ChatGPT subscribers. Would it help your adversary to know that you were searching for ways to prevent your complaint from being barred by the statute of limitations when he or she is coming up with possible arguments for a motion to dismiss? All of these consequences are speculative and hypothetical, but the fact remains that using ChatGPT to perform legal research and to create and refine legal documents on behalf of a client creates a real risk that you are failing to comply with your ethical obligation to safeguard client property and data under ABA Model Rule 1.15. Is there a potential solution for concerns about failing to safeguard client property and data? Yes, and it's the same two possible solutions we saw before: informed client consent and running a proprietary instance of a generative AI tool that only has access to a law firm's own documents and data. If you did either of those things, you could use generative AI in your law practice without risking your law license for having failed to safeguard your client's property and data. The fourth area of concern for practicing lawyers is your ethical obligation to be candid before the court. ABA Model Rule 3.3a provides that, quote, "A lawyer shall not knowingly, 1. Make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2. Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Or 3. Offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence, other than the testimony of a defendant in a criminal matter, that the lawyer reasonably believes is false," end quote. If you think about the conduct of the ChatGPT sanctions lawyer, it's easy to see how a lawyer who relies on ChatGPT to find case law to cite to a court violates ABA Model Rule 3.3a. I would point out that the requirement that false statements of law must be made knowingly in order to violate this rule would not save a lawyer who blindly relied on ChatGPT given all of the disclaimers that ChatGPT provides, as we have seen. Just as recklessness satisfies the intent requirement in many areas of civil and criminal law, I have no doubt a court or the state bar would find that a reckless reliance on the results of a ChatGPT search to find case law support for an argument made to a court that the lawyer failed to verify would meet the standard of knowingly false statements of law under ABA Model Rule 3.3a. Unless and until such time, if ever, that ChatGPT or other generative AI tools can be found to give reliable answers to questions posed by lawyers, similar to how Westlaw or Lexis will return actual cases in response to your search results, the solve for this concern is not to use ChatGPT for legal research at all, or if you do, to independently verify any content that ChatGPT generates. Like a well-written summer associate legal memo, the temptation may be there to rely upon what you are being shown, but just like that legal memo, you simply can't unless you want to run the risk of a legal ethics violation, not to mention sanctions, and not to mention a very, very unhappy client. The fifth area of concern for practicing lawyers, which is closely related to the fourth, is your ethical obligation not to bring frivolous claims. Once again, the main driver of this issue is the lack of accuracy and, frankly, the very real risk that case law and other content can be made up out of whole cloth associated with ChatGPT content. ABA Model Rule 3.1 provides that, quote, "A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law," end quote. Rule 11b of the Federal Rules of Civil Procedure provides as follows, quote, "Representations to the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, An attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, 1. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4. The denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information." End quote. The key language in ABA Model Rule 3.1 is, quote, "a basis in law and fact for doing so that is not frivolous," end quote, which you cannot have if you rely on ChatGPT to do your legal research, or factual research for that matter, without independently verifying it. Under Rule 11, the place to focus is the requirement that, quote, "the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances," end quote. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law, end quote. For the record, the bit about establishing new law does not refer to law that ChatGPT simply makes up. Recall, the window that opens when you launch ChatGPT that expressly states, quote, "While we have safeguards in place, the system may occasionally generate incorrect or misleading information and produce offensive or biased content. It is not intended to give advice," end quote. On the ChatGPT homepage, under the section entitled Limitations, it states that ChatGPT, quote, "may occasionally generate incorrect information, may occasionally produce harmful instructions or biased content, and limited knowledge of world and events after 2021. A lawyer who relies on ChatGPT does not have a belief, quote, "formed after an inquiry reasonable under the circumstances," end quote, that, quote, "the claims, defenses, and other legal contentions are warranted by existing law," end quote, as required by Rule 11. Nor does the lawyer know, quote, "there is a basis in law and fact that is not frivolous," end quote, for asserting such claims, defenses, or other legal contentions as required by ABA Model Rule 3.1. For this ethical concern, the only potential solution is to independently verify any legal research or other content generated by ChatGPT that you are tempted to use in your practice. Obviously, informed client consent doesn't cover you for documents containing frivolous claims, defenses, or other legal contentions that get submitted to a court. ChatGPT is a B+ law student, and you'd never submit a motion drafted by a law student to a court without independently checking every aspect of it. If you keep that in mind, you'll stay clear of liability under ABA Model Rule 3.1 and Rule 11 of the Federal Rules of Civil Procedure. The personal injury lawyer who was ordered to pay $5,000 as a sanction under Rule 11 was not so lucky. While the federal district judge who sanctioned the lawyer did not expressly refer him to the New York State Bar, the State Bar very well may take up the case on its own initiative, given how much publicity this case has received. As a result, it remains to be seen whether that lawyer also will face legal ethics charges. You don't want to find yourself in a similar situation ever. The sixth area of concern for practicing lawyers is your ethical obligation to supervise non-lawyer staff. ABA Model Rule 5.3, which is entitled, quote, Responsibilities Regarding Non-Lawyer Assistants, end quote, states that, quote, with respect to a non-lawyer employed or retained or associated with a lawyer, a partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. B, a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And C, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if 1. The lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action, end quote. In addition, in August 2019, the ABA House of Delegates passed Resolution Number 112 that provided, quote, resolved, that the American Bar Association urges courts and lawyers to address the emerging ethical and legal issues related to the usage of artificial intelligence, AI, in the practice of law, including 1. Bias, explainability, and transparency of automated decisions made by AI, 2. Ethical and beneficial usage of AI, and 3. Controls and oversight of AI and the vendors that provide AI, end quote. Some commentators have pointed out that non-lawyer assistance in ABA Model Rule 5.3 includes non-human assistance of the sort that ChatGPT provides. The ABA resolution is very clear when it counsels lawyers specifically to make sure there are, quote, controls and oversight of AI and the vendors that provide AI, end quote, such as ChatGPT. Just like when lawyers delegate tasks to paralegals, law students, or vendors, ABA Model Rule 5.3 requires the lawyer to ensure that he or she has measures in effect to give reasonable assurance that the person's conduct upholds the lawyer's professional obligations. If you give client documents to a vendor for analysis, you need to have an agreement in place with the vendor that requires the vendor to keep those documents confidential. If you ask a paralegal to research a factual issue, you need to make sure that his or her work is adequately supervised and reviewed. If you ask a law student to write a legal memo, you need to independently verify the legal analysis and conclusions contained in that memo. As we've seen, ChatGPT offers no assurances about confidentiality, no way to audit the process by which it does factual research when you ask it a question, and no confidence that its legal research and/or legal analysis is valid or even based on actual laws and cases. Accordingly, any lawyer who relies on ChatGPT to assist him or her in the practice of law risks violating ABA Model Rule 5.3. The solution to this ethics issue is not to use ChatGPT at all in connection with your law practice, but if you do, to treat your non-human, non-lawyer assistant similar to how you would treat paralegals, law students, and vendors. Think carefully before asking them to do anything, and before inputting any client confidential or proprietary information, as we've already covered, and then take whatever steps are needed to ensure that the work they're doing complies fully with your legal ethics obligations. In some cases, like the point about factual research, it's virtually impossible to audit how ChatGPT is arriving at the answers to your questions, versus a human paralegal who can explain to you the process by which he or she found the answers and the sources he or she consulted. So you basically have to redo any factual research. Accordingly, ChatGPT isn't going to save you any time there. The same is true of legal research and legal analysis. The current version of ChatGPT is so unreliable and can actually make up cases that don't exist that anything it produces would need to be wholly redone. So, no time saved there either. And always the temptation not to redo all of the analysis, which is probably worse than starting with nothing. The other reason not to use ChatGPT is to remember the many benefits of giving these tasks to paralegals, law students, and associates. Although clients hate it, the fact remains that the only way lawyers to be, and more junior lawyers, learn the skills they need to be senior lawyers is by doing. One risk of relying on ChatGPT for mundane or lower-level tasks in order to improve efficiency is that senior attorneys will be less likely to spend the time training young lawyers by delegating these tasks to them. It isn't such an issue right now because ChatGPT is so unreliable. But as the technology improves, senior lawyers might be more inclined to delegate to ChatGPT the tasks he or she previously would have given to those paralegals, law students, and junior lawyers. That would be a mistake because the next generation needs to learn how to be lawyers, and they learn by doing. It's the same problem we have with remote work. It's clearly efficient, and people, young associates, senior associates, and many partners, all love it. But the only way young lawyers learn how to behave in a client meeting or in a deposition is to be in the meeting or the deposition, sitting next to the senior associate or partner, and observe how they behave. Much of that is lost on Teams or Zoom. There is also the mentorship and camaraderie of being in the office together, pulling a late night to finish a brief or to sign a merger agreement that remote work can never replace. I think an over-reliance on ChatGPT stands to impact young lawyer training negatively in the same ways that remote work can, and we need to guard against that. The seventh area of concern for practicing lawyers is your ethical obligation to avoid the unauthorized practice of law. ABA Model Rule 5.5a states that, quote, "A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so." The easy version of this is the personal injury lawyer who relied exclusively on ChatGPT to provide the case law support for his opposition to a motion to dismiss. That's assisting someone, albeit a non-human someone, in the unauthorized practice of law. You may have seen the headlines about a company called Do Not Pay that used to specialize in offering legal services, including legal document generation and online dispute resolution for certain preset legal issues like parking tickets, flight delays, and landlord-tenant disputes. In January 2023, Do Not Pay planned to take it to the next level by having an AI chatbot similar to ChatGPT help a defendant fight a traffic ticket in a California state court. The defendant was going to wear smart glasses that both record court proceedings and dictate responses into the defendant's ear from a small speaker. In a related publicity stunt, Do Not Pay had offered $1 million to any lawyer who would argue before the U.S. Supreme Court wearing a similar set of gear through which the lawyer could receive instructions from this, quote, robot lawyer, end quote. It will not surprise you to learn that Do Not Pay dropped both efforts after receiving threats of possible prosecution and jail time for violation of the criminal statutes that prevent the unauthorized practice of law. Clearly, that's the easy case. Robot lawyers violate the laws against unauthorized practice of law, and if you're a lawyer, you also violate ABA Model Rule 5.5a if you assist in any such practice. The harder case is partial reliance on ChatGPT to perform legal research, generate legal documents, engage in legal analysis. For now, the lack of accuracy makes this a non-starter for the reasons we've already covered. But this technology will get better. Just look at how far it's come now in just a few years. And it will become more accurate, perhaps even to the point where it is reliable. Then what? Think of a human lawyer who does a good job and knows a particular area of law such that you could rely on his or her legal research and analysis. But that lawyer isn't licensed to practice. It's just ChatGPT in a future incarnation. Now, you can argue with my premise. ChatGPT will never be able to become a true robot lawyer because it can never appreciate the nuances of legal analysis. It can never have the real-world experience of practicing lawyers, and it can never exercise the sort of legal and other sound judgment that makes lawyers lawyers. But if somehow ChatGPT ever got that good, it would be assisting the unauthorized practice of law in violation of ABA Model Rule 5.5 to use ChatGPT in that way. There really isn't a solve for this ethical issue, except that if we ever get to a place where ChatGPT could be a reliable, quote, junior associate, unquote, the legal ethics rules, including ABA Model Rule 5.5, would need to be changed before lawyers could make use of such a robot lawyer. The eighth and final area of concern for practicing lawyers that we're going to discuss today is your ethical obligation not to discriminate against others on the basis of protected characteristics. ABA Model Rule 8.4g provides that it is professional misconduct for a lawyer to, quote, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules, end quote. The issue here is that ChatGPT is a large language model that trained on a massive data set of text and code. That data set may contain biases, which could be reflected in the output of ChatGPT. This could lead to discrimination in some form against people on the basis of protected characteristics. It's really difficult to know what biases might exist in the large language model dataset because it is so massive and there is little transparency into what it includes. Really, all we know is that it excludes anything created after 2021 which is a critical limitation. But in terms of what's in there, we don't know. But there is a lot of concern in the field of AI generally about potential biases in that data set. Let's assume that of all the text and code that is in the ChatGPT dataset, and just playing the odds here, more of that text and code was written by white men than African American women. Or maybe more of it was written by people of any sex or race who identify as straight than those who identify as LGBTQ+. We have no idea if any of this is true, but let's assume the dataset exhibits some patterns that are different from a dataset that would be truly representative of the world's population as a whole with regard to the protected characteristics identified by ABA Model Rule 8.4G and similar anti-discrimination laws. Because the dataset is not representative, the concern is that the output ChatGPT generates will be biased in some way. Remember, ChatGPT does not know anything except patterns. There is no concept of right or wrong, truth or falsity. To take it to an extreme, if the dataset on which ChatGPT was trained consisted solely of text, documents, images, audio, and other content generated by white supremacists, you'd fully expect the output it generates to reflect that same bias. Asking that version of ChatGPT to write an essay about African American or Jewish history almost certainly would produce a document that was highly offensive and discriminatory on the basis of race. The worry is that the normal ChatGPT would suffer from the same problems due to biases that are present in its data set. How do lawyers address this problem? Well, technology may solve it first if they are able to come up with a data set for a future ChatGPT that includes literally everything, although for obvious reasons that everything still might be biased because not everyone has equal access to the tools to create content in the form of text, documents, images, music, audio, etc. that exists online in a form that ChatGPT could access it. But the dataset could get a lot better, and so the risk of bias could be lessened. The other solution is for lawyers to exercise a heightened degree of care to scrutinize the outputs from ChatGPT for signs of bias and to correct them before acting on any of that potentially biased content. Easier said than done because it's difficult to know how ChatGPT actually generated the content it is showing you. What sources did it use? But certainly, obvious signs of bias, such as referring to a person or group of people by a derogatory or incorrect name, could be caught if lawyers are engaging in independent review and exercising independent judgment with regard to ChatGPT outputs. If lawyers do that, I think they are discharging their ethical obligations under ABA Model Rule 8.4G, not to discriminate on the basis of protected characteristics as it relates to potentially using ChatGPT content in their law practice. While we are on the topic of anti-discrimination, I would be remiss if I didn't mention the very real possibility that ChatGPT can greatly benefit members of protected classes, particularly those who don't have ready access to lawyers or legal advice. As Dean Perlman noted, quote, nearly 90% of people living below the poverty line and a majority of middle-income Americans receive no meaningful assistance when facing important civil legal issues, such as child custody, debt collection, eviction, and foreclosure." End quote. Technology, including ChatGPT, offers the potential to address those needs, both without the direct involvement of lawyers and by helping lawyers serve more clients, which would do a lot to benefit members of protected classes. Recall the example of asking ChatGPT how to address a Social Security underpayment. The chatbot did a decent job of providing advice that an individual could act upon without needing to hire a lawyer. More complex matters like child custody are harder, where strategy, judgment, experience, and other factors make lawyers very hard to replace, and unauthorized practice of law issues abound. At bottom, the unauthorized practice of law statutes are intended to protect the public from bad lawyering and, candidly, to protect the economic interests of lawyers. But perhaps a middle ground could be found where ChatGPT provides good advice that people who have no access to a lawyer could follow to their great benefit. This is the flip side of concerns about bias arising from ChatGPT. The promise that ChatGPT could help to address the current gap in the provision of legal services to underrepresented communities. In conclusion, I asked ChatGPT, quote, "How can lawyers use ChatGPT without violating their legal ethics obligations?" End quote. And here is what it said. Quote, "Lawyers can use ChatGPT without violating their legal ethics obligations by following these guidelines. Be aware of the limitations of ChatGPT. ChatGPT is a machine learning model, and it is not perfect. It can make mistakes, and it can be biased. Lawyers should be aware of these limitations and should not rely on ChatGPT to provide accurate or unbiased legal advice. Use ChatGPT in conjunction with their own legal expertise. ChatGPT is a tool, and it is not a substitute for a lawyer's judgment. Lawyers should use ChatGPT to supplement their own legal knowledge and experience, but they should not rely on ChatGPT to make decisions for them. Be transparent with their clients about the use of ChatGPT. Lawyers should disclose to their clients that they are using ChatGPT to assist in their representation. They should also explain to their clients the limitations of ChatGPT and the potential for bias. Take steps to mitigate the risks associated with using ChatGPT. This includes using ChatGPT in a secure environment, encrypting communications, and restricting access to the technology. By following these guidelines, lawyers can use ChatGPT without violating their legal ethics obligations. However, it is important to note that the legal landscape is constantly evolving, and lawyers should stay up to date on the latest developments in legal ethics. Here are some additional tips for lawyers who want to use ChatGPT ethically. Start with a clear understanding of the ethics rules that apply to your practice. This includes the model rules of professional conduct, as well as any specific ethical rules that apply to your jurisdiction. Consider the specific ethical concerns that are raised by using ChatGPT. For example, you need to be aware of the potential for bias and the need to protect client confidentiality. Develop a plan for how you will use ChatGPT in a way that complies with the ethical rules. This plan should include steps for mitigating the risks associated with using ChatGPT. Get feedback from colleagues and mentors who are familiar with the ethical rules. This can help you ensure that your plan is sound and that you are using ChatGPT ethically. By following these tips, lawyers can use ChatGPT in a way that complies with the ethical rules and that protects their clients' interests." End quote. I'd say that's definitely a B+ answer. I hope you enjoyed today's program. Thanks for joining me.